Guys, welcome back to another exciting episode of the Sigma Real Estate Studios. And my, oh my, what is New York just passed? So in this video, we're going to be going over Bill number 811181, also known as the C-19 Emergency Eviction and Foreclosure Prevention Act of 2020. Now say that 5 times fast. I'm not going to wait. Let's go. Now the main purpose of this bill is to, number 1, to prevent evictions and proceedings seeking eviction against residential tenants experiencing financial or health-related hardships. Number 2, to prevent foreclosure against homeowners and certain small landlords with financial hardships. Number 3, to prevent certain tax liens and tax foreclosure proceedings. Number 4, limit reporting in certain actions based on certain delinquent payment information and to prevent the discrimination against certain borrowers. And number 5, to extend the senior citizens homeowner exemption and disabled homeowner exemption without requiring recertification. Now, if you like the sound of this, then go ahead and hit that like button. That's my like button. Now, this is also something really interesting in this bill. So it allows certain proceedings to continue if the court, in response to an authorized new petition, finds that the tenant is persistently and unreasonably engaging in behavior that substantially infringes on the use and enjoyment of other tenants or occupants or causes a substantial safety hazard to others. I like this rule because this basically says is, hey, if the tenant that you have, they're irresponsible, they're always causing a ruckus, they're making it unsafe for other people to live there, there's still a way to evict those people and the courts will allow that. So for all the tough guys out there, hey, this bill doesn't protect you anymore. Here are some additional cool points for my landlords and homeowners. So this bill allows borrowers who own 10 or fewer residential dwellings, including their primary residence, and are experiencing financial hardship to file a hardship declaration with the mortgage lender, other foreclosing party, or the court that will prevent the filing of proceedings on a foreclosure action until May 1st, 2021. Now, what I like most about this is they're allowing, so not only is it the tenant that gets a break, but if the landlord or the homeowner is also in a similar situation, well, now they're going to get a break too, and I'm a fan of that. So what about taxes? Well, this bill prevents local governments from engaging in any tax lien sale or tax foreclosure until May 1st, 2021 for such property of a residential property owner who owns 10 or fewer units, including their primary residence, who is experiencing financial hardship and files such a hardship declaration. So once again, if you're a homeowner, you own less than 10 properties, or 10 residences, I should say, including the one you live in, this is something that you can do. So make sure, file that hardship declaration. Now, this one I thought was extremely interesting. It prohibits lending institutions from discriminating in the determination of whether credit should be extended to any owner of residential real property, 10 or fewer units, because the owner has been granted a stay of mortgage foreclosure proceedings or tax foreclosure proceedings or tax lien sales, or the owner is currently in arrears and has filed a hardship declaration with the lender. The moral of this story seems to be you have to file that hardship declaration. If you don't do that, well, you can't get help. This one, it prohibits negative reporting to any credit reporting agency based on the stay on the filing or proceedings on any mortgage foreclosure proceeding, tax foreclosure proceeding, and tax lien sale, or mortgage arrays during the C-19 period with respect to an owner who has filed such a hardship declaration with the lender. Now, I don't know how they're going to track this one exactly. It'll be very interesting to see how the creditors react. And for anyone who's a senior citizen or has a disabled homeowner exemption, this requires local governments to carry over your exemptions from the 2020 assessment roll into 2021. And this is the part I love most. It bars any requirement that a recipient be required to personally appear to file a renewal if the renewal is required. It's going to be very interesting to see how New York kind of moves forward with this whole thing. You know, drop a comment down below with your 2 cents on what you think is going to happen to New York, its people, and whether this is a bill that you would have supported or if it's a bill you would have turned down, because not everybody voted this bill in. They keep saying sweeping, but I would say it's not sweeping. Like, there was a lot of people, I think it was around 20 people voted against the bill. So listen, I hope that this video will help those in need and will prevent third parties from taking advantage of those who are or misinformed. Okay, so please, if you need help, speak to your accountant, speak to your attorney. You can call a real estate agent if you have one. If not, my information is down below in the Calendly link, so feel free to reach on out to us. Just the worst thing you could do is sit there and wait for something to change. The change starts with you. So please, if you need help, seek it out. You know, nobody's going to come knocking, giving you free money. And as usual, if you want to be notified when more news on real estate and more real estate videos are released, then go ahead, hit the subscribe button, ding the bell, and I will see you here next time. I'm your host, Jimmy Odone, and boy, I don't understand how politicians do it with these bills. Like, they just write it in English, man. Save the trees.